Alright guys, I hesitate to even make this video because it's on a very technical and complex topic, but I recently consulted with a guy who knew his stuff. Like, he had done his research, he'd clearly been reading up on different parts of immigration law for a while, and he understands that he needs a 601A waiver to waive his unlawful presence. And I'll explain what that is for people who don't know in a second. And he asked me this question. He said, so am I correct in understanding that immediate relative category family petitions do not need a 601A waiver, and preference category petitions do need a 601A waiver? And my answer was, not exactly, but you kind of are getting like half of the picture here. And let me explain. So the first thing is, a 601A waiver is for people who are not eligible to adjust status inside the United States. If you've been unlawfully present in the US for more than 180 days and you depart the US to attend a consular interview, or for any reason actually, you'll trigger a 3-year bar preventing you from legally re-entering. The government will not have the power to allow you back in, even if they want to, unless you qualify for a 601A waiver. And if you've been unlawfully present in the US for more than 1 year continuously and you depart the US, you are subject to a 10-year unlawful presence bar. You won't be allowed back under any circumstance. Well, I shouldn't say that. You could still be like paroled in for humanitarian reasons. Consulates can still make mistakes and allow you in through their error. It happens all the time. But legally, you're not supposed to be allowed to re-enter the US for 10 years. You'll trigger a 10-year bar the moment you step foot outside of the United States. And actually, just, current events, there was some guy who had DACA, Deferred Action for Childhood Arrivals, who made a wrong turn in like Southern California and accidentally like dipped into Mexico for a second and tried to come back. And now he's detained and probably subject to a 10-year bar. And it's unclear how that's going to play out, but that is a terrible situation. And he is very much deportable from the United States right now because he triggered that bar, and for other reasons. He doesn't have lawful immigration status in the US aside from DACA, which just prevents the government from deporting you. But, he kind of like self-deported by physically leaving the US. Anyway, I digress. Back to the main topic. So the question becomes, who needs to leave the US to become a permanent resident? And this video is for people who are already in the US, whether they're lawfully present in the US, or they entered with visas and overstayed, or they entered the US without inspection or illegally, and they just like entered the US through some border or snuck in or something like that. So let's start actually with that last one. If you entered without inspection, you always have to leave the US to attend a consular interview, unless after your entry you've been paroled or you qualify for an exemption under something called 245I, which is for people who entered the US before April 30th, 2001, or other very, very rare exceptions like military parole in place, where you have a family member who's in, like a direct family member who's in the military. The government can just like snap its fingers, grant something called parole, and that just fixes your illegal entry. And now it's kind of like a legal fiction, but now you have a document that says you were paroled, which might make you eligible to adjust status in the United States. If you entered without inspection, usually you have to leave the US at some point to attend an interview. For example, a family member files a petition for you, the visa becomes available, you'll eventually need to leave the US. And if you have more than 1 year of unlawful presence before you leave the US, you're gonna need a 601A waiver to be approved to fix that unlawful presence before you leave. And these 601A waivers can take like 3 to 4 years currently to get approved. But I'd rather you be waiting those 3 to 4 years in the US than attend your interview at a consulate in your home country, find out you're subject to a 10-year bar. There's another way you could apply. It's a 601 waiver for unlawful presence. You would submit that directly to the consulate, but you could be waiting in your home country for like 6 months to 2 years or longer, depending on the consulate and their processing times. The reason for the 601A waiver is it allows you to waive it while waiting inside the United States. Although, under current policies, you could still be detained or deported. Historically, that hasn't happened, but I wouldn't be surprised if that starts happening now. Okay, now for those of you who've made it this far, you're probably in the minority and interested in like getting into the weeds on complex immigration law topics. There's a difference between immediate relative category petitions and preference category petitions. Immediate relative category petitions have a visa immediately available, and when you file this type of petition for an immigrant, they could be out of status and still apply for adjustment of status from within the US as long as they entered legally or have been paroled after the fact. So if you have an immediate relative category petition and you entered with inspection or parole, then you're probably eligible for adjustment of status in the US and you do not need a 601A waiver. I say probably because, there are exceptions, but generally speaking, that's the case. Preference category petitions are every other category of petition. That's permanent residents filing petitions for spouses, permanent residents filing petitions for parents, kids, US citizens filing petitions for siblings, which currently takes like 16 years, US citizens filing petitions for adult sons or daughters, whether they're single or married, will change the processing times, but these are all preference category petitions. Preference category petitions, people who qualify for a preference category petition are only able to adjust status from within the US if they entered legally and when they apply for adjustment of status, a visa is available on the preference category petition and they are currently in a valid non-immigrant visa status. It's very rare for all of these conditions to be met, but I have had some cases and I do screen everyone to see if they're eligible to adjust status in the United States. If they have more than 1 year of unlawful presence, or they've overstayed their visa, or for some other reason they need to depart the United States to attend a consular interview, if they have more than 1 year of unlawful presence and they've overstayed their visa, they're going to need a 601A waiver in a preference category petition. If they have more than 1 year of unlawful presence and a visa is not available, a visa priority date is not current on the day they submit their adjustment of status application, they're going to need a 601A waiver. So this is very complicated, but it basically comes down to, do you have more than 1 year of unlawful presence? And do you need to leave the US to attend a consular interview, or are you eligible for adjustment of status in the US? I've seen people making a lot of mistakes recently, and I probably should have started the video with this statement. I've seen tons of people who are out of status and who file preference category petitions, especially like people whose TPS is being terminated and they're just desperate. They file I-130s and adjustment of status applications, waste a ton of money, and actually getting that adjustment of status application denied will place you into removal proceedings. So don't be that guy. If you're about to do your own application, at least talk with an attorney, consult with an attorney, even if you still plan to do the whole thing yourself and you want to save some money, which I don't recommend doing right now because the stakes are too high. Speak with an attorney to make sure your strategy isn't doomed before you even begin. And just like financially speaking, you might not be able to afford an attorney, but the adjustment of status with an I-130 and a work permit, like right there, you're spending almost $2,400. And if you end up in removal proceedings, you're gonna need an immigration attorney. That's gonna add $8,000 to $12,000 to your bill. So, sometimes not speaking to an attorney can be more expensive. If you're considering filing an I-130 petition, speak with an attorney because the situation right now is not normal and you need to understand the risks you might be taking. All right, guys, that brings us to the end of today's video. If you want to consult with me about any family-based immigration matter, my consultation information, including a direct booking link, is in the video description below. You could schedule a consultation in like 5 minutes. It's super easy. My name is Puyan Darian. I'm an immigration attorney with an office in New York. I practice immigration law nationwide and have clients nationwide. If you need assistance with anything, feel free to reach out. If you want to stay up to date on all the latest immigration news, changes under the Trump administration, policy changes, be sure to subscribe. Anytime I hear about something new, I try to create a video, give you a unique perspective on the matter, and I'll see you guys next time for another video.